The UNCITRAL introductory rules regulate the initial phase of the arbitration, which requires the claimant to submit a notice of arbitration and the respondent to reply with a response to that notice. To that end, the rules list the required information that the claimant must include in the notice of arbitration as follows. First, a demand that the dispute be referred to arbitration. Second, the identification of the names and contact details of the disputed parties. Third, the arbitration agreement invoked by the claimant. Fourth, the contract or any other legal instrument out of which the dispute arises, and a brief description of the claim. Fifth, the remedy or relief sought by the claimant, and his proposal regarding the number of arbitrators, the language, and the place of arbitration, if not previously agreed between the parties. In addition, the notice of arbitration may also include other optional details, such as the claimant's suggestion for the selection of an appointing authority, or the proposed name of a sole arbitrator, or the name of the arbitrator selected by the claimant. As the arbitration starts when the respondent receives the notice of arbitration, the respondent must submit his reply within 30 days of receiving the notice. Once received, the respondent has the option of accelerating the proceedings by including additional details to his response, like any proposals to the selection of the appointing authority, or the appointment of a sole arbitrator, or to name the arbitrator appointed by the respondent. The respondent can also add to his response a brief description of his counterclaims and any objection to challenge the tribunal jurisdiction. The UNCITRAL arbitration rules also ensure that any inadequacies, insufficiency, or delay in the submission of the notice or the response do not prevent the arbitration from moving forward, as the tribunal has the power and discretion to proceed by fixing the filing of an insufficient notice or response.